Good morning, ladies and gentlemen. Welcome to the subcommittee. There is, in all likelihood, someone's going to go to apply for a job today, and the employer's not going to tell him or her this, but the employer's going to say, you know, I'm not comfortable with the way that person looks, with the way he or she presents him or herself, so I'm not going to hire the person. In all likelihood, someone today is being considered for a promotion or an opportunity in his or her job. And behind closed doors, an employer may well say, you know, this person makes us uncomfortable because of the way he or she looks or he or she presents him or herself. Under the present state of the law, if that's the reason given to deny someone a job, to fire them from a job they already have, or to deny them a promotion or move up, under federal law, it is legal. It is permissible to do that. I will confess to you a bias from the outset that to me this makes no sense whatsoever. I think if someone is the best code writer at the software company, they should get the job. I think if someone is the best auto mechanic, they should get the job. I think if they'd be the best bank teller, they should get the job. The question of someone's orientation, someone's presentation, should be absolutely irrelevant to the consideration of whether they get the job or the promotion. The purpose of this hearing is to explore the law in this area, which I would start from the premise of saying that it does permit these kind of denials to take place, and whether that should change or not. I think it should. I think it should. We're going to hear this morning from a number of witnesses who will provide a varying number of perspectives on this question. One of the elemental principles in American law, we hope, is merit. That whether or not someone is hired, whether or not someone is promoted, whether or not someone has economic opportunities is a function of how well they do their job, or how well they would do their job, and not a function of what I would call irrelevant prejudicial criteria. I feel strongly that someone's presentation is an irrelevant criterion. I think it has nothing to do with how well someone writes code or conducts bank transactions or fixes someone's car. And I aspire to the day when the law will protect every person in that position, and that he or she is able to go to work, do as well as he or she can, and be judged on performance at work and not on prejudice of any other decision maker. We're going to hear from a variety of witnesses this morning who will address those concerns, and we look forward to vigorous questioning from the members of the subcommittee as we move forward. I would also note for the record that there is context for this hearing, and that was this committee and the House's consideration of the Employment Non-Discrimination Act in the fall of 2007. It needs to be said, it needs to be reminded, that the bill that passed the House of Representatives did not include protection for transgendered people. I believe it should. And the purpose of this hearing is for those of us who believe that to make our case, and for those who disagree to make theirs, and for people to draw an intelligent and rational conclusion from that debate.